I call the Honourable Member Raymond Ho.
Thank you, Kia ora, Mr. Chair. Before I start, I would like to acknowledge the great work done by the Honourable Rick Barker. And I would like to thank the National Government for carrying out the great work initiated by Labour while in government. And like my colleagues, Lim Play and Jacinda Ardern, in their early speeches in this House, both expressed it is regrettable because Labour would like to see one overarching agency with responsibility for fines, but there is no provision for this in the legislation. Part 1 amends the District Courts Act 1947. Attachment orders are used to allow deductions to be made from wages and benefits to pay debts. At present, attachment orders can be imposed only after an examination hearing to assess the judgment debtor's ability to pay the debt. Both parties are required to attend the hearing, which can be inconvenient and incur delays and costs. So this bill aims to streamline this enforcement process by enabling judgment creditors to file a financial statement or ask the court to assess the debtor's financial means in the debtor's absence. We have received 15 submissions, and I'd like to acknowledge the great work done by the officials. They have done a tremendously good job. Some of the submitters commented on the changes to attachment order. Those in favour of the changes commented that the change would create better outcomes for creditors. The opposing view was that these changes have the potential to create a situation where attachment orders are imposed at a level that is unsustainable and potentially imposed without the debtor's knowledge. And one concern in particular was that an individual may be subject to enforcement action without being aware of this as a result of the removal of these requirements. And another issue was the change to the service provision, and some submitters commented that the extension of the service provisions to enable creditors to complete a service more efficiently would result in a more expedient enforcement process. Others were concerned about relying on the presumption of service and the weakening of the current service provisions. Thank you, Mr. Chair.
Mr. Chair.
I call the Honourable